Now, former President Jacob Zuma has more days to spend at home. The Constitutional Court has agreed to hear his application to have his sentence rescinded. His application will be heard by Apex Court on Monday, the 12th of July. This means the former president will not go to prison for now, as was initially expected. Now, according to court papers in possession of the SABC, opposing parties on the matter have until July 6th to file their cases. Now, for analysis, we joined now via Skype by constitutional law expert and director of accountability now, Professor Paul Hoffman. Professor, thank you so much for your time this afternoon. Help us make sense of the latest developments. With the hearing of the ConCourt, the ConCourt has agreed to essentially hear the former president's application. Help us unpack exactly what this means as it relates to his committal orders.
Yes, good afternoon. Thank you for making me a professor. I'm just an advocate, but the promotion is most welcome. The circular from the Constitutional Court deals only with the rescission application. There is no stay application pending before the Constitutional Court as far as documents reaching the public domain are concerned. But I am sure that the parties will agree among themselves or will approach the Constitutional Court for a directive if they can't, that the warrant for the arrest will be held over till there is judgment following the hearing that is set down for the 12th. You will notice in the circular that the court has put out that the court reserves the position that it may issue further directives. It's, I think, to cover that eventuality. So there's a timetable exchanging documents and suggested, both affidavits, replying affidavits, and heads of argument, all of the parties that were before the court and the police as well. And the hearing will be a virtual hearing starting at 9 o'clock on the 12th of July. It'll be interesting to see what the Zondo Commission's attitude is to the rescission application, based as it is on the error of law, and a possibility exists that there will be counter application or notices to the applicant and his legal team in relation to liability for the costs of this rescission application.
Apologies, advocate. I will not call you prof. Now, as it relates to the directive that was issued by the ConCourt to the SAPS, are you saying to us that they have now also agreed to, step back and obviously not arrest the president even after that time of the 3 days which follows the deadline, which was initially Sunday? After that deadline, the SAPS will hold off until this matter has been heard and completed by the Constitutional Court.
It seems to make sense to do that, but I have not seen a separate notice to the police. I have only seen one consolidated notice to 5 respondents that include the police and the Zondo Commission and Ellen Suzman Foundation. The current position is that no stay application has been launched in the Constitutional Court. But I imagine that a directive can be issued about that if there is not an agreement between Mr. Zuma and 5 respondents that the writ should not be acted on while the decision application is pending. it makes perfect sense, because if the rescission application happens to be successful, Mr. Zuma will be in jail for a week.
Yeah, so that was going to be my next question. So with this decision now that the ConCourt will hear the former president, so it surely makes his stay, of application to the Pietermaritzburg court that much more easier, doesn't it?
I don't believe that the Pietermaritzburg court has any jurisdiction in the matter. The court that issued the warrant for the arrest of Mr. Zuma is the court that should be approached in relation to stay. But certainly, if the Pietermaritzburg court does have jurisdiction, and because the matter has been given an accelerated hearing in the Constitutional Court, it seems to me to follow that there should be no arrest until there is a determination by the Constitutional Court of the rescission application.
Now, Advocate, the ConCourt judgment that was made on Tuesday was lauded by many, and, it was deemed basically unprecedented, historic, etc. What is this latest decision by the ConCourt to hear the former president's application tell us about, just some of the initial reaction to this judgment? Does it in any way put some form of a dent on that initial judgment, particularly because we had, two schools of thought in terms of what the outcome should have been initially?
Look, what we need to remember is that although there was a minority judgment, the judgment of the majority is the judgment that binds the party. That follows from Section 165 of the Constitution. So, whereas the minority thought that coercive punishment would be appropriate, majority said, we're not going to waste our time trying to coerce Mr. Zuma. We are taking the attitude that we can only punish him because he is delinquent and recalcitrant and not able to see that he is in wrong and in contempt and overdue to purge his contempt. So what the current application really entails is an aggravation of the contempt by Mr. Zuma because of the way that he has gone about that rescission application. But the court believes in the audi alteram partem rule, which is the rule that says you hear the other party, and it's giving Mr. Zuma the opportunity to put the arguments that support the application in argument to the court, so that dealt with by the other parties and ruled on by the court. Makes no dent at all in the Tuesday majority or minority judgment.
Advocate, I might be putting you in a very difficult position by asking you this next question, but should the rescission application not go favorably for former President Zuma, what are we likely to see?
Well, I think that it is likely, and this is only an opinion and I'm speculating, the papers are not in, attitudes have not been taken by the respondents. But I'm expecting that the application will be opposed, that the application will be exposed as a stunt and an abuse of the process of the court, and that there will be punitive costs award that are in the discretion of the Constitutional Court for being trifled with by Mr. Zuma and his legal.
And when the former president, Mr. Zuma, does go to, in front of the Constitutional Court, talk to us about who is likely to hear this this particular matter, because we know currently that the acting Chief Justice is Justice Raymond Zondo.
Yes, Justice Raymond Zondo will not hear this matter. It will be heard by the same judges who participated in the decision-making that was made known to the public on Tuesday this week.
All right. Advocate Hoffman, always a pleasure to get your input and analysis on the story. Thank you so much for your time this afternoon. That was Advocate Paul Hoffman saying there that it's an opinion that he's giving, that he does think that this matter will be opposed by the Constitutional Court.